item on our agenda is the minutes from the January 11th, 2021 meeting of the Rules Committee. Is there a motion to approve?
Judge Bellis, so moved.
Is there a second?
Judge Pratt, second.
Thank you. Are there any corrections to the minutes?
No, sir. Not that I know.
All right. If not, all in favor say aye.
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 Opposed say no. That passes unanimously. The next item on our agenda is 2019-003 regarding standard written discovery in medical malpractice cases. And I believe Judge Bellis is going to address us on that. Is that correct?
I am. Thank you. So this is sort of a supplemental report to Judge Cobb's exhaustive report the last time it was down. And I know she named all the members and thanked them. We're very grateful to all their hard work. So we sent, Joe sent the latest drafts out a month or so ago to CTLA and CDLA. We received their comments. The working group, I think, met twice and had a phone conference as well since then. And I can probably report in 2 minutes or less on what changes we made in response to their concerns and what changes we didn't make. So let me start, if I can, with the two changes that the CTLA wanted that we ultimately agreed would be best left for another day because it would affect standard discovery as well. So the CTLA was looking to limit the lost wage, loss of earning capacity production request that we sort of lifted off the standard. And after much discussion, we decided that perhaps CTLA could raise it again formally so that all the shareholders could weigh in, that so any changes that could be made to the lost wage and loss in earning capacity interrogatories and production request would be across the board, so that so we wouldn't end up with MedMal saying one thing and the standard saying the other. So we did not make any changes to the lost wage or loss of earning capacity that we lifted off the standard. Same thing with the insurance policies. The CTLA wanted production of the insurance policies. Again, we lifted the insurance interrogatories and production requests from the existing standard discovery. And although many of us thought that it would be an appropriate request to actually get the insurance policy, particularly in light of Practice Book 1312, which allows for it, we didn't make any change on the MedMal because we wanted it to be consistent with the existing standard discovery. So that should probably reach us maybe next year when it's re-raised. So those were the two things that we sort of punted on. We did make changes in response to CTLA's request that we merge the production requests for healthcare providers and medical groups so that two sets were not being served. So we merged that. We also agreed with their request that with respect to the situation of agency, were admitted that the interrogatory regarding affiliations and would not have to be answered. That was interrogatory 14 and interrogatory 3. And with the CDLA, we agreed ultimately with their request on EMRs, electronic medical records. So we've deleted a few of those interrogatories. So that leaves maybe 4 remaining issues that one side or the other had issues with that we didn't make the substantive changes. So CDLA had some objections with respect to interrogatory 17 on protocols. So what we had done was we compromised the working group. We asked the question about protocols, but we did not have a corresponding production request. We figured that was as good a compromise as we could get. CDLA either wanted the interrogatory itself deleted or limited to 52-198 good faith certificate inquiry, and we did not make that change. So that might be something that CDLA will have an issue with. CDLA had an issue with regard to production request 1 or 2, depending on what document you're looking on, with regard to obtaining patient records. We did change that a little bit to make sure that the privilege was clear, so that privileged records were not being turned over. But we did not make the entire change that CDLA wanted. CTLA wanted to limit the production request for educational records. We did not make that change. So we did not think that was appropriate. And CTLA wanted the audit trails produced, and we did not agree to that change. So we reached a consensus, at least among the working group, and it did leave a few issues where, we didn't have total consensus. So when the documents that were included in this month's agenda, when you compare them to the last time they were on the agenda, you'll see, a handful of changes and then a couple minor technical changes. So I think I could, either Judge Cobb or I could probably answer any questions anyone has about any individual interrogatories or production requests.
Thank you. Well, first, let me extend my gratitude to Judge Bellis, Judge Cobb, and Judge Stevens, who helped lead up this effort, but also a big thank you to the 6 members of the bar who have put in so much time over so many years working on this. From what I am gathering from Judge Bellis's report, this is a pretty much a consensus product, at least around certain things. It sounds like if we were to adopt these changes, there might be opportunities in the future to revisit the subject on a more granular level. But getting this big package together is a big step forward. And I do want to thank everybody involved for that effort. Judge Cobb, did you want to say anything?
Well, I want to thank everybody as well. It really was an amazing effort, and we so appreciate the time and energy that the members of the bar provided to us. And I agree with so far everything. Well, I never disagree with Judge Bellis, but her description and of what has happened over the last recent weeks since my last report is what's been happening over the last few weeks. That I don't have anything to add to that.
Okay. Are there any, from members of the committee, are there any questions of either Judge Bellis or Judge Cobb? All right. Attorney Petrozelli, did you raise your hand?
Hi, Justice McDonald. This isn't a question, just a comment I raised with Judge Bellis, and she asked me if I could just raise it in front of the committee today, and it's very small. It's in plaintiff's interrogatories, hospital and/or medical group, and there was some renumbering done. So there's an internal reference to interrogatory number 17, which I think Judge Bellis had just mentioned that there weren't any corresponding production requests to go with that. But 17 was renumbered as 16. So we just ask for the committee's leave to make that change in the numbering.
And we freely give that leave so you can protect us from ourselves.
Okay, thank you very much, Your Honor.
Are there questions from members of the committee? If not, with all of the hard work behind us, is there a motion to approve this package of changes?
So moved, Judge Farley.
And is there a second? We need a second.
Second, Judge Pratt.
Seconded by Judge Pratt. Is there any discussion on the item? If not, all in favor, say aye.
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 Opposed, say no. That passes unanimously. Again, thank you, everybody, for the hard work. We do appreciate it. And it's always better getting something by consensus if possible. The next item on our agenda is 2019-014, a proposal from Senator Looney, Senator Winfield, and Representative Staffstrom regarding pretrial discovery in criminal matters. Attorney Del Campo.
Yes, Your Honor. This matter was considered last meeting in January, at which time I conveyed a message from Judge Gold requesting that the matter be tabled to allow additional time for Judge Gold to confer with the proponents from the legislature. No new materials have been added to this meeting. I do believe Judge Gold is in attendance at the meeting. He may wish to update this matter further. I'm not sure. I know he did send out information to the legislature. I'm not certain what information has been received back.
I
Thank
see
you.
Judge Gold on my screen, so I'll turn it
Thank
over
you.
to you, Judge Gold.
All right, thank you very much. I'm going to ask that the matter be tabled until next month. I'll explain why. After the Rules Committee's last meeting, I did send a letter to Senators Looney and Winfield, as well as to Representative Staffstrom, the three proponents of the proposed change. I've had an opportunity to discuss everything with Senator Looney, who reached out to me by telephone, and we were able to discuss the changes, and he's on board. I've also exchanged emails with Representative Staffstrom. He is also on board with the changes. I have not heard back from Senator Winfield at all. In the letter that I did send out, I mistakenly said that I didn't have a calendar in front of me at the time, and I said that our meeting was going to be next Monday, which it obviously isn't. And I said in the letter that I asked to get a reply, if possible, by February 11th. So that's one reason I would ask that we hold off until March, just in case Senator Winfield takes the opportunity to convey to me any concerns that he has with the proposal as it's being presented to the Rules Committee. As a further reason for asking for a final tabling this until next month is that I received an email late last week from a member of the Innocence Project, not the Connecticut group that's through the Office of the Chief Public Defender, but what I'm told is the New York Innocence Project, and they wish to talk to me about the bill, or the proposed change anyway. And I thought it might be a good idea that I spoke to someone from that agency before we move forward. I have a telephone conference set up for tomorrow. That was the earliest we could meet. So we're meeting tomorrow by phone at 4 o'clock to discuss any position they might have on this. So for those two reasons, so that I can hear from Senator Winfield if he wishes to be heard on this, and also so that I could speak with the representatives from the Innocence Project, I'd ask that we table this till the March meeting.
If people are not addressing the committee, if you could please make sure you're on mute, that would be helpful. Thank you for that report, Judge Gold. Joe, we have next month as our final opportunity to take action on items.
Well, yes, final meeting for new business. If you don't get it adopted or recommended next month, then it won't go to a public hearing. You will have another opportunity in May to consider things, but if they don't go to a public hearing, they can only become effective on an interim basis. So that's really the key to next month, is to get it on the public hearing agenda.
Thank you. I certainly would be willing to take this up next month, Judge Gold. If you, I also have Senator Winfield's cell number. If you want to call me, I can provide that to you as well, so you can reach out to him.
If I'll reach out to you then, if you think that's appropriate. I did leave a message on the the Senate number for Senator Winfield and also sent the letter. I haven't heard back from either of those.
Give me a call after this meeting, please.
Yes, sir.
Okay, is there any objection to holding that item for another month from members of the committee? Hearing none, thank you. We're going to move on then to item 2020-12, which is the proposal from the CBA regarding a change to the rules of professional conduct, 8.4G. I believe that when we had this item last on our agenda, the committee asked Attorney Del Campo to formulate a working group to try to address some of the issues from the Statewide Grievance Council, and he has sent out a report of that effort, but I'll hand this over first to Attorney Del Campo to summarize that effort.
Yes, sir, you're correct. The working group was comprised of Attorney Bowler, Statewide Bar Council, attorneys Marcy Stovall and Attorney Cecil Thomas from the CBA, and my staff and myself. We just facilitated their discussion. The working group met on January 27th. And after a lengthy discussion, the CBA decided that it would not, at least as a result of that discussion, revise its proposal that is before you. I believe attorneys Stovall and Thomas and Bowler are here to update you on that. There have been no changes. There's no new material from the last time. There is a new letter from the CBA explaining what we did do or what was discussed at the working group, and the fact that at least at that point after that meeting, they were not going to revise the proposal. But I will turn that over to them.
Well, let me first ask, as I understood the report, the areas of concern that had been identified by the Statewide Grievance Council were part of the subject matter of the working group's efforts, but there was no suggestion about how to resolve those problems by the Statewide Grievance Council. Was I reading that correctly?
Yes, I believe Attorney Bowler is here, so he can explain.
Okay.
The Statewide Grievance Committee did not take a position. They made certain observations. So Attorney Bowler can explain it. But basically, they were there to facilitate discussion, and there is no position being taken by the Statewide Grievance Committee. They just pointed out some issues that they thought were relevant, and the CBA took them under advisement, and again is here today to discuss it more fully.
I apologize. I overlooked his name on the participation list. Attorney Bowler, are you available?
I am here, Your Honor, if you can. I'm here, Your Honor, if you can see me.
I can hear you at least.
I turned on my camera. Yeah, there I am.
So did you want to address this any further or no?
No, I don't think I need to, Your Honor. I think Attorney Del Campo summarized it properly. Again, the Statewide Grievance Committee isn't taking a position on it. We'll refer to the committee's email to Attorney Del Campo on December 29th. It raised certain observations about both the definitions used by the Connecticut Bar Association in their submission. There's also, as mentioned, point 3 is our concern that this rule may be covered by other rules of professional conduct and whether it's needed. The Statewide Grievance Committee made that observation as well. But after we suggested that the CBA may want to revisit whether they wanted to add formal definitions to the rule, such as the main rule does, or whether they wanted to keep what they considered to be the definitions in the commentary, as is in the current proposal. And after discussing the matter, my understanding from receiving Attorney Thomas's latest letter is that the CBA was going to pursue it as is.
Okay, thank you. And before I ask Attorney Thomas to address the committee, let me first see if Attorney Stovall would like to address this item at all.
Thank you, Your Honor. I'm going to let Mr. Thomas take the lead.
Fair enough. Mr. Thomas, Attorney Thomas.
Thank you, Your Honor, and thank you to the members of the Rules Committee for your consideration. Before I get started, should I speak only to the work of the working group, or should I address the subject of the rule more broadly?
I would. It's your show for the moment.
Okay. Well, if I may, just because this is the first time I think we've had the opportunity to address the Rules Committee substantively on this proposal, I'll take a few minutes just to talk about the development of the rule and the history. Back in June of last year, the Rules Committee was presented with ABA Model Rule 8.4G. The Rules Committee at that moment asked the proponents of that rule, Attorney Megan Wade and Attorney Anya Goldsby, to work with the Connecticut Bar Association in the development of the rule and to submit supporting materials to the Rules Committee thereafter. And so over the course of the summer of 2020, the CBA formed a 8.47 working group. I served as the chair of that working group, and that working group included representatives from the CBA Standing Committee on Professional Ethics, including Attorney Stovall, members of our Diversity, Equity, and Inclusion Committee, several of our past presidents, experts on labor and employment law as well. And so developed the rule that is, or the proposed rule that is before you, which was submitted after extensive CBA consideration to the Rules Committee in September of 2020. I won't go through the extensive process that took place in the CBA, but I will just note that having spoken to several others that are familiar with the CBA's processes, this rule went through quite an extensive process, having been considered and approved by 11 sections and committees before being presented to the Legislative Policy Review Committee, then to the Executive Committee, and then to the CBA House of Delegates that ultimately voted in favor of the proposed rule with a supermajority, 39 in favor, 11 opposed, 1 abstention. I want to take just a minute to talk about some of the reasons for the proposed rule. Obviously, the Rules Committee had asked us to submit a version of the rule. We have done so back in September. But we have a couple of motivating factors, one of which is that currently language regarding discrimination in or bias in professional contexts is limited to the commentary to Rule 8.44, which defines misconduct when an attorney engages in conduct that is prejudicial to the administration of justice. And in the definition thereof, it indicates that when an attorney in the course of representing a client engages in certain biased or discriminatory behavior, that conduct would constitute professional misconduct. We've submitted to the Rules Committee the results of a CBA survey that sought to gather from Connecticut attorneys their experiences with discrimination, harassment, and sexual harassment in professional contexts. Perhaps unsurprisingly, the results of our brief survey echoed the results of national surveys. And so just to talk a little bit about our profession's diversity and inclusion crisis, statistics reveal that 86% of all lawyers nationally, as maintained by the American Bar Association, identify as Caucasian or white, and only 37% of lawyers identify as female. In the Connecticut Bar Association has taken some efforts to quantify since 2016 the state of diversity, equity, and inclusion within the Connecticut legal profession. And again, our numbers are very similar. We have a significant lack of representation within every sector of the Connecticut legal profession of women, of racially and ethnically diverse lawyers, of lawyers who identify as lesbian, gay, bisexual, or transgender, and as lawyers who identify as people with disabilities. And I don't mean to equate that lack of representation solely with experiences with discrimination, but I think what the numbers reveal is that not only are diverse lawyers a relatively small part of our profession, but that also that, as evidenced by our survey results, as well as the national survey results, that in addition to the burden of being one of the few or one of the only in many professional contexts, that women attorneys, that diverse attorneys, racially and ethnically diverse attorneys, that attorneys who identify as having disabilities or of LGBTQ plus status report experiencing discrimination, harassment, and bias overwhelmingly. The national statistics or survey results, one in particular done by NextGens, reveals that 75% of women lawyer respondents had direct experiences with sexual harassment or misconduct, with 73% of those respondents describing such experiences as occurring often or frequently. And again, our own survey results, more than half of our respondents in a survey that just spanned 5 full days reported that they had experienced discrimination, harassment, or sexual harassment based on membership in a protected class and conduct related to the practice of law. That was about more than half of our respondents. 44% of our respondents reported that they had witnessed discrimination, harassment, or sexual harassment based on membership in a protected class in professional contexts at some point during the practice. And the majority of these instances were reported as taking place within the workplace in the context of client representation, in the context of personnel decisions, professional meetings, activities, or events, bar associations, meetings, activities, or events. And this is an unfortunate reality of the practice of law for diverse attorneys. And so when this rule came before the CBA, we thought it important to not only support this rule and ensure that it went through the appropriate processes before the CBA, but also to make sure that we address common concerns. And I understand from our previous discussions of this rule, or this committee's previous discussions of the rule, that the focus of these discussions should not be on the constitutional issues, but just very quickly, we did make a significant effort to address concerns of constitutionality or to address concerns of overbreadth, resulting, I think, in the support that you've seen for this rule. I note that there are a number of comments, and perhaps a significant number of comments that have been received in response to this proposed rule. I would note just in general observation that many of those comments are directed to the ABA version of the rule and do not specifically contend with the CBA's revisions to it, that many of those comments appear to be copies or part of national campaigns against adoption of ABA Model Rule 8.4G. And our rule differs meaningfully from that rule. I will note that what you have before you is support from the Connecticut's Attorney General, from all 4 of Connecticut's affinity bar associations, the deans of the 4 Connecticut area law schools, the leaders of 28 major Connecticut law firms, legal aid organizations, government and corporate legal departments, all of whom have signed on in support of the rule, and the Lawyers Collaborative for Diversity. A great deal of thought and effort has gone into into the development of this rule. I want to address the definitions concern. Specifically, we had a very productive conversation with attorneys Bowler and Staines several weeks back, ably facilitated by Attorney Del Campo and his staff, and I am grateful for those efforts. I will note that in reference to the main rule, for example, defines harassment to use the word includes. And so the Statewide Grievance Committee has raised a concern over the use in our proposed definition of the use of the word includes. And again, referring to the main rule, I note that it uses the words includes, but it's not limited to when defining harassment, and in particular sexual harassment. Turning to Connecticut substantive law on these issues, for example, Connecticut General Statutes 46A51 subsection 6 defines discrimination to includes segregation and separation. Discrimination on the basis of sex is defined as includes but is not limited to discrimination related to pregnancy, etc. And discrimination on the basis of religious creed is defined to include but is not limited to discrimination related to all aspects of religious observances and practice. And so our use of the word includes is not used in a vacuum. It was intended to capture the substantive law. And turning to the specific language of our proposal, you will see that as to the definitions, we've proposed some definition that discrimination includes harmful verbal or physical conduct directed at an individual or individuals, that we've sought to define harassment to include severe or pervasive derogatory or demeaning verbal or physical conduct, and that ultimately we have sought to constrain all of these definitions with the line that is included, which is that the substantive law of anti-discrimination and anti-harassment statutes and case law should guide application of paragraph 7 where applicable. So our use of the word includes in our use of that language referring to the application as guidance of the anti-discrimination and anti-harassment statutes was a recognition that this substantive area of law is an expansive one, and where those definitions that we would refer to, even to the extent that we were to try to incorporate those fully into the rule, would use language such as includes but is not limited to. We can provide, consistent with the purposes of the rules, certain guideposts, and we think it important that our ethical guideposts for the ethical practice of law make it clear that discrimination, harassment, and sexual harassment on the basis of protected statuses have no place in the practice of law. We believe that this is a rule that is long overdue. And we think it important, given this moment that we're in, given all that we know about attorneys' experiences, particularly diverse attorneys' experiences with discrimination and harassment, that we address discrimination and harassment within the express language of our rules. And we note also that to the extent that the rules encourage us to frame these rules as ethical guideposts, that our framing of the rule is consistent with the remainder of 8.4. 8.4 lays out a number of grounds under which an attorney can be defined to have engaged in misconduct, but all of those are framed in very general terms. Those definitions are often used to lay out some of the parameters without laying out every possible circumstance under which conduct can run afoul of the rule. And so our proposed rule and the amended commentary are entirely consistent with that approach. And so that, again, we strongly urge the Rules Committee to adopt this rule, and I would certainly welcome any questions, comments, or concerns from members of this committee.
Well, thank you. That was very helpful for me, at least, because I read a lot of these comments months ago, and I remember a lot of the things, reading a lot of things that you just referenced. I want to thank you and the members of the CBA for all of the work that you have put into this. I was a member of the CBA for 20 plus years. I don't think I've ever seen such a robust process in all of that time put into a rules committee change. It was a very significant undertaking, so I appreciate all of that work. I'm going to open this up to members of the committee to ask questions of Attorney Thomas, Attorney Stovall, or Attorney Bowler, if anybody has questions for any of those three individuals at this point. If you do, please raise your virtual hand. Okay. I don't think, does anybody have any questions? There we go. Judge Farley.
Yeah, Attorney Thomas or whoever wants to respond to this. You know, one of the concerns that was raised wasn't so much about whether we needed the rule and I agree, a lot of the comments really weren't applicable, but the ones that I found raised issues for me were the most important one, I think, was that too much of the substance of the rule was put into the commentary. And you know, I think that was one of the comments at the last meeting. You know, shouldn't we bring some of that, such as the definitions of discrimination and harassment, into the rule rather than leaving them in a commentary? And I wanted to know, I was curious to know what your thoughts were about that, and why you decided not to do that.
Certainly, I'm going to take the first shot at answering this, and then if Attorney Stovall has further comments, I hope that she will weigh in as well. In looking at the development of the rule, I think if you look at 8.4 subsection 7 as proposed within the context of 8.4 currently, the rule as framed would be the longest rule or statement of a rule among the existing 6 enumerated grounds under which a lawyer could be found to engage in professional misconduct. And I don't mean to point merely to the length of the rule as a reason not to sort of include more in the language of the rule itself. But our thought was that the rule itself makes a statement of what conduct the rule is considered to be misconduct. And so stating a general principle that lawyers should not engage in what they know or reasonably should know is harassment or discrimination on the basis of race without significant qualification or without extensive carve-outs within the context of the rule appeared to be consistent with the framing used in other sections of that same rule. And so, again, 8.44, engage in conduct that is prejudicial to the administration of justice, or 8.43, a lawyer shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. All of those rules state general principles that serve as guideposts. And our thinking on this is that the purpose of this rule, or any of the rules really, is not primarily about the disciplinary context, but to serve as that ethical guidepost to define how lawyers should conduct themselves. And I think going back to the earliest statements of our professional principles, we've always stood for the premise that we should treat all individuals equally, particularly our brothers and sisters before the bar. And so that was the thinking in the development of this rule, that certainly the terms that we've used, harassment, discrimination, harassment on the basis of sex, are terms that are well defined, but also expansively defined within the substantive law and within the related case law. And so we wanted to draw that in while at the same time not making the rule so lengthy as to be impossible to decipher. Specifically to I think some comments have been submitted by, I believe, the Hartford County Bar Association that suggested that the line that we have included that refers to First Amendment protection, specifically a lawyer's conduct does not violate paragraph 7 when the conduct in question is protected under the First Amendment or the Connecticut equivalent. That was described in the commentary in part because of the general rule of construction that rules should not be interpreted to violate the Constitution. And so again, in the framing of the rule, we have directed the subject of the rule to conduct and not to speech alone. We rely, at least in part, on that general rule of statutory construction. And then to the extent that there was any question in anybody's mind that the purpose of this rule is not to reach conduct that would be protected under the First Amendment of the U.S. Constitution or the Connecticut constitutional equivalent, we've included that language in the commentary. And again, believe that framing of the expansion of the rule in the commentary is consistent with all of the other provisions of 8.44. Or 8.4, sorry.
One other question. A lot of comments also focused on the discussion of conduct related to the practice of law in the commentary, and specifically that last line in the that sentence where conduct related to the practice of law includes events in connection with the practice of law. I'm sure you saw those comments. I just wondered what your response to them were.
So, Your Honor, if you took some, if you had the opportunity to review some of the responses that we received to our survey, unfortunately, both the national surveys and our own survey reveal that much of this conduct, unfortunately, occurs in contexts that are professional in nature or related to professional activities. And so the specific language is participating in bar association business or professional activities or events in connection with the practice of law. Our intent there was that conduct that arose to the level of discrimination, harassment, or sexual harassment taking place within those contexts at bar associations in business or professional activities or events would still violate the rule, that there was not some safe harbor simply because, for example, in referring to the current language of 8.44, the commentary there only speaks of conduct in the course of representing a client. And certainly national studies as well as our own survey results show that unfortunately much of this conduct takes place in those broader professional contexts.
Well, okay, that may clarify something for me, because if I understood what you're saying, then the word events is modified by the word professional. In other words, professional events. That's what you're meaning to get at. It's
That
not
is
that
correct, Your Honor.
clear to me. So professional activities or professional events. So I saw one comment, this could be a backyard barbecue. Your intent is not to bring backyard barbecues within the scope of the rule.
It is not, Your Honor. And I'd also highlight that in the ABA version of the rule included a reference to social activities. We removed that reference to social activities. And certainly it is not our intent to bring a backyard barbecue into the scope or the coverage of the rule. And so the language again is business or professional activities or events in connection with the practice of law. And part of that again is unfortunately, this is often unfortunately where those there may be alcohol involved or perhaps some blurred lines of professional contexts. But unfortunately, I think to the extent that the types of harmful conduct that we're describing here take place in those contexts, it is no less harmful simply because it took place at a bar association event or because it took place at a professional networking event.
All right, thank you very much.
And I would just add, and I remember early on in my professional career, firm outings and firm Christmas parties were areas of concern. Let's put it that way. And a number of firms discontinued them because of situations that arose involving harassment of staff members once alcohol was introduced into the event. And so I understood that language to be of events to be professionally related, even if it is a barbecue at the managing partner's backyard, that it would cover that. Is that correct, Attorney Thomas?
That is correct, yes.
Okay. The other thing I would ask Attorney Del Campo is, there he is. He popped up just as I wanted him. I just refreshed my recollection. We adopt the commentary language. The judges vote on it just as we vote on the rule. And so it's no less substantive in terms of the import of the interpretation of the rule if it's in the rule versus the commentary. Is that correct, Joe?
These commentaries for this are part of the code, as opposed to a Rules Committee commentary, which is attached to a run-of-the-mill change to a rule. The effect that a commentary has on this type of rule versus any other is likely different. I mean, Mike Bowler might want to speak on that. But it is different than a Rules Committee commentary. Certainly, the judges are asked to adopt these rules with the commentaries. They are not asked to adopt the commentaries that the Rules Committee puts out in explanation of its recommendations for rule change.
Right, but this is official commentary that the judges would vote on.
Yes.
Okay.
Yes.
Yeah, I mean, I didn't do it in anticipation of this meeting, but there have been certainly instances where I've written opinions that the commentary is given essentially equal force with the actual language of the rule. But Attorney Bowler, do you want to address that issue?
Well, I'll just read to you from the scope, which is part of the introduction to the rules of professional conduct. I don't have the 2021 official practice book yet, but this is on page 3 of the 2020 practice book. And to the extent that we're equating, there's any suggestion that the commentary is equal to the rule, I believe that the introduction.
I'm sorry, it informs what the rule is intended to accomplish.
Yes, the commentary, if I could just read it, the commentary accompanying each rule explains and illustrates the meaning and purpose of the rule. The preamble in this note on the scope provides general orientation. The commentaries are intended as guides to interpretation, but the text of each rule is authoritative. So,
Fair enough. Okay.
Yeah. To the extent we need clarification on that, I think it's spelled out by what's been adopted.
I appreciate that. Thank you.
Mhm.
Were there other questions for any of the attorney participants from members of the committee? If not, let me just make sure I'm not missing anybody. Okay. Is there discussion amongst members of the, well, why don't we do it in a formal way? Is there a motion to approve the proposal as submitted by the CBA for the modifications to include subparagraph 7 of Rule 8.4? Is there a motion to approve?
So moved. Judge Cobb.
Judge Cobb, is there a second?
Second, Avery Whetstone.
Seconded by Avery Whetstone. Thank you. Is there discussion from members of the committee? If not, Judge
Your Honor,
Bellis.
Judge.
Thank you. The discussion is on now the amended proposal.
Correct.
Yeah.
It's the red line version is the last 2 pages of the September 11th, 2020 submission.
Right. So I would just have to say that I'm opposed, strongly opposed to the proposal. I think that existing Rule 8.44 is applied robustly, which is what the Office of Disciplinary Counsel and Statewide Grievance has pointed out. I don't see that it's been inadequate. I've had more than my fair share of attorney discipline matters. And I don't have any doubt that our small state with our small integrated bar and integrated court system is in good hands. So I don't doubt that there is a problem with discrimination with diverse attorneys. I don't doubt that at all. I think it's very serious, and I was concerned as everyone else when I saw that survey. I just don't see how passing another rule is going to make a difference, given that the existing rule is sufficient. So I think that maybe it should be addressed in other ways. I'm not sure what the answer is, but I just don't see that there have been complaints or I think the problem is that the complaints or the discrimination is just not being reported, and there was no reason that it couldn't be reported under the existing rules. And I have no doubt that once reported, it would be handled more than appropriately. So that's my position.
Okay. I would just say that as somebody who is in a diverse legal categorization and has had professional discrimination, experienced it, having something in writing that the bar has put its muscle behind and the judges have put their muscle behind is a important way in which people who are discriminated against are given the real opportunity and the clear path to assert the fact that they have been discriminated against. And it is an acknowledgement by the profession that they will have an avenue to have those issues identified and dealt with appropriately. I don't profess to suggest that this rule isn't somewhat duplicative of some other rules, but it is also definitely more expansive. And so I appreciate your comments, Judge Bellis. I just don't share them in this instance. Are there other comments from members of the committee? If not, all in favor of approval, say aye.
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 Opposed, say no.
No.
Judge Bellis is in the negative, and I didn't hear anybody else in the negative. So we should record the votes because we're required to under the Freedom of Information Act. Okay, I appreciate that. And again, thank you, Attorney Thomas, Attorney Stovall, Attorney Bowler, for all of your help. That item will go to the public hearing in May. Is that right, Joe?
Yes, sir. Yes,
Okay.
May 10th.
Okay, May 10th. Thank you very much. The next item is item 2020-20, a proposal from Teco Kim to adopt a code of conduct for judicial employees. We asked last month that Attorney Del Campo share the proposal with the Chief Court Administrator's Office and divisions within that office. And we've gotten a response from Brian Hill from Human Resources saying that this code is not necessary because it's already covered by judicial branch policies and collective bargaining agreements. Is that correct, Joe?
Yes, it is. Judge Carroll did echo that response. He indicated that there already exists a robust processes in place to address these concerns, and there is a solid and transparent record of actions taken by the branch in these matters.
Okay.
So they did not take up the issues in any substantive sense in terms of making any changes.
Do any of the members of the committee have a contrary view? If not, is there a motion to table this item?
So moved, Judge Bellis.
Is there a second?
Second, Judge Barley.
Is there any discussion? All in favor, say aye.
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 Opposed, say no. That item will be tabled. Thank you. The next three items are all on our agenda for the first time. The first is 2021-1, a proposal from Jeff Gentes from the Connecticut Fair Housing Center to amend Section 3.8b regarding limited scope appearances. Attorney Del Campo?
Yes, this is on for the first time, although there was a similar proposal on, as Attorney O'Donnell pointed out to us, back in 2017, 2018, and she has given us the history of that. Basically, this proposal, as did the previous proposal, seeks to remedy what is deemed a potentially indefinite representation. The concern is that if items go over on the court calendar or after they're heard, if they're continued, then there's an indefinite period of time, could be months or years, that the attorney is obligated to represent the individual even on the appearance, limited appearance. So that's the crux of this. This proposal is slightly different than the original proposal. It does allow a client to make a written objection within, I think it's to the court within 10 days after written notice has been given or mailed to the client that that the matter is intended to be reclaimed. And it used to say at least 30 days after the short calendar. Now it says 30 days after. So there is 30 days after the short calendar on which the motion appeared. If the motions have not been submitted, reclaimed, or continued to a specific date, then the limited appearance is removed. So that is the difference in this. It was on before, though, and you did choose to deny or to not take up or recommend the proposal back in 2017, 2018.
Thank you. Although I don't think any of the members of the committee were on the committee at that time, but I understand that was the action that was taken at that time. Is there any discussion, or can we just refer this out to the CAJs for comment first? Judge Bellis.
Is that something that we have to do, or can we have a consensus as to whether we should even do that? Because I didn't think that the difference was significant enough to warrant going through that whole process again.
No, it's not something we have to do by any stretch of the imagination. Frankly, I just didn't want to make the assumption that members of the committee who are on the committee now shared the same opinion of the members in 2017. But let's open this up for discussion about whether or not we need to take any further action on this. Oh, lots of silence. Any guidance from members of the committee about what they'd like to do? Judge Cobb.
I just wanted to say that I agree with Judge Bellis. I don't think it's necessary to move forward on this proposal.
Is there any contrary view? Okay, Judge Bellis, is that a new hand that you have up, or? You're muted.
I apologize. I just wanted to make clear that was my position, that I didn't think we needed to move forward on it.
Fair enough. If there's no contrary view, is there a motion to table this proposal?
So moved, Judge Prats.
Is there, and I'm going to say Judge Bellis is the second, just the law. All in favor of tabling it, say aye.
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 Opposed, say no. That passes unanimously. Next item is 2021-2, a proposal from Judge Conway for changes to the practice book consistent with the Supreme Court's decision in re Zakai F. Attorney Del Campo?
Yes, Your Honor. This was submitted by Judge Conway. Basically, she's asking that practice book section 35A-20 be amended to apply to parents whose guardianship has been removed, who are seeking to have it reinstated. There's a new rule that has been also proposed, which is 35A-20A, which breaks out any other person who is a guardian who wants to regain guardianship. There's also the question of the standard that the Supreme Court issued in Zakai, the question of whether or not there was constitutional presumption that reinstatement of guardianship rights to a parent under 45A-611 is in the best interest of the child, and whether or not there's a heightened standard of proof. So these questions are addressed in the text of the two rules are proposed. They propose that these are addressed in the body of these new rules, and that's the basis for the submission.
So I looked over the rule changes, and as I understand it, the separation is to make the distinction between a parental situation and a non-parental situation, because Zakai only dealt with the parental motion for reinstatement, correct? Well, I know what Zakai said. But
Yes, Your Honor.
Okay, so I don't know that we need to. I looked them over. It looks right. It's in conformity with my court's opinion in Zakai. I don't know that we need to send it out to anybody. If there's a contrary view, let me know. Otherwise, we can accept a motion to approve. All right. Is there a motion to approve the changes to bring our practice book into conformity with the Supreme Court precedent?
So moved, Judge Bellis.
Second, Judge Cobb.
Any discussion? All in favor, say aye.
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 Opposed, say no. That passes unanimously. The next item on our agenda is the proposal from the Statewide Grievance Committee for an amendment to section 2-27D concerning attorneys' home addresses. Attorney Del Campo.
Yes, sir. That is a proposal, as you indicate. All attorneys need to register with the Statewide Bar Council, Statewide Grievance Committee, their business address. Sometimes people don't do that. The default then is they usually always have a home address or some type of address to which things can fall back to. In the event that it falls back to their home address, there are sometimes issues with that. This tries to set forth the idea that if you don't give a business address, then the default will be whatever is there, and it's basically the home address. So nobody is surprised by that. Again, Attorney Bowe is here. He can much better articulate the proposal, and I should let him do that.
Attorney Bowler.
Thank you, Your Honor. I think Attorney Del Campo actually summed it up quite nicely. I realized that this submission is sort of all marked up, but this submission is an addendum to a submission to change section 2-27 that was adopted or passed through the Rules Committee a couple of months ago. So when I suggested this change on behalf of the Grievance Committee, I double underlined the change and I numbered the submission. The proposed change is found between lines 38 and 41 of section 2-27D, in that I proposed a new commentary to explain why. When a lawyer practices or is admitted to the bar of the state of Connecticut, they are required to register both an office address and a home address. Generally speaking, office addresses are always public and home addresses are not. The problem, as Attorney Del Campo pointed out, is that too many attorneys, even if they are practicing law, do not register their office address, primarily because they don't want judicial mailings to go to their office for whatever reason. And so our system, which was built back in the mid-1980s, in which does everything from assigning jurist numbers when you're admitted to putting in a date of death when you die as a lawyer, and everything in between, including grievance complaints, was created back around in the Reagan administration. So it's difficult to work with on its best days, but it feeds everything. So when a lawyer enters an appearance in court with a jurist number, that clerk's system then looks to this old database for the information about the lawyer. If the lawyer has not registered an office address, the system will immediately default to the registered home address. And so the lawyer's home address, which is otherwise not public, will be displayed to the public on the judicial branch's public-facing website for our attorney lookup feature. And the other issue is if the lawyer has not registered an office address and is grieved, when we send out mailings to that lawyer, that mailing will go to the lawyer's registered home address. It's the only contact address we have for the lawyer. And then that address, which would otherwise not be public, can become public if probable cause is found, and it's always available to the complainant, the complainant's counsel, the disciplinary counsel, and the respondent's counsel, because for statewide grievance committee purposes, parties to a grievance complaint are not considered members of the public for purposes of the information in the record of their complaint. So a complainant could get a copy of the record and see that an attorney's home address. So this proposal really codifies longstanding practice in the office to give, and we've also developed a series of FAQs that are on our grievance committee website as well, to codify, to let attorneys know that while the general rule is that home addresses are not public, they can become public in the situation where the lawyer fails to register an office address. I might add that lawyers are obligated to register an office address under section 2-27D, and it's misconduct not to under section 2-27F. But that's that rule, the enforcement of that rule is difficult, if not impossible. It's more honored in the breach than the observance. So we thought it best, in addition to FAQs explaining this process that predates me by many years, that in addition to the FAQs, we should codify that reality in the practice book, hence the proposal to the Rules Committee.
Are there any questions from members of the committee? I don't know that this item needs to be sent to anybody for input. It looks like an effort to bring our rules into conformity with our antiquated computer systems.
Thank you, Your Honor.
All right. Is there a motion to approve?
So moved, Judge Cobb.
Thank you, Judge Cobb. Is there a second?
Second, Avery Whetstone.
Thank you for the second. Any discussion? All in favor, say aye.
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 Opposed, say no. That passes unanimously. The last item, I think, is 2021-4, proposal from the CBA to revise Rule 1.8 of the Rules of Professional Conduct. Attorney Del Campo?
Yes, sir. This proposal, this proposed amendment would permit a lawyer representing a client pro bono to provide modest gifts to the client to pay for basic living expenses. This is from the CBA. Again, the members of the CBA are here. Perhaps Attorney Stovall would like to present the CBA's proposal more fully. Attorney Stovall.
Attorney Stovall, I see your fingerprints on this.
Yes. Well, it's not just my fingerprints, Your Honor. It's this is actually the CBA's adaptation of a rule that the ABA adopted at its annual meeting in August of 2020. And it's a proposal that's often referred to as a humanitarian exception. Let me back up just a little bit. As a basic tenet, Rule 1.8E prohibits a lawyer who's representing a client in a litigation matter from providing financial assistance to a client. There are a couple of exceptions to that rule already, one of which is that the lawyer can pay for court costs or costs related to the litigation. This new exception is a very limited exception that applies only to a very narrow category of attorneys in certain kinds of clients, that a lawyer would be allowed to provide financial assistance for basic living expenses where the lawyer is representing the client without a fee. So it would not apply to any lawyer who is representing a client on the basis of a contingency fee, but it would permit a lawyer who's representing a client in situations where there's a possibility of statutory fee shifting. This financial assistance would be permitted. The Connecticut proposal makes adds a few tweaks to what the ABA has already adopted in further limiting the ability of a lawyer or the authority of a lawyer to provide this kind of financial assistance. An additional limitation is that a lawyer wouldn't be permitted to offer this kind of financial assistance in order to induce a client to take action, take or refrain from taking action in the matter in which the lawyer is representing the client. The other differences between the CBA version and the ABA version are in the nature of style and clarity, and to reduce some redundancy between the rule and the commentary. In the ABA version, a significant amount of what's in the rule is also repeated in the commentary. So we've left it in the rule, but deleted it from the commentary. When this rule was proposed at the ABA, there was no significant opposition. There was no opposition at all. And there was an inquiry made of the National Organization of Bar Counsel or disciplinary authorities in other states. If in the I think 11 jurisdictions that had a similar rule, if there had been problems encountered, only 2 jurisdictions replied, I believe, but there was no report of any difficulty or any unforeseen problems arising out of this adoption of this exception or a similar exception.
Thank you. Are there any questions for Attorney Stovall? Judge Bellis.
I just have a quick question, and this may be a dumb question, so I apologize in advance. If you have an attorney who has an indigent client who can't pay their basic living expenses, and say they take the case on and it takes 7 years to work its way through to trial and such, but it's on a contingent basis, why? So I'm just trying to figure out, why is the differentiation pro bono or contingent fee? Why is it okay if it's pro bono, but the same indigent client who can't pay their living expenses and isn't going to see anything for 7 years, why can't they get help?
Well, I mean, it is possible to, to adopt a rule that way, but my understanding is that there's generally been resistance to such a rule in most jurisdictions, because if lawyers are allowed, who are obtaining a fee, are allowed to provide this kind of financial assistance to clients, my understanding, and I'm sure that that Mr. Bowler could speak to this more directly than I could, but there's a concern that the words that are often used are champerty and maintenance, the idea that lawyers would then be buying litigation or offering this kind of financial assistance in order to essentially benefit themselves, buying clients, buying litigation matters. And the concern is often expressed because often the concern is that these kinds of transactions would be viewed as loans, and that gives the lawyer an interest in the litigation above and beyond what he or she would ordinarily have in just having a contingency fee. So it certainly would be possible to provide that lawyers, even in contingency fee matters, could provide this financial assistance, but there's generally a reluctance to permit that kind of those kind of financial transactions between lawyers and clients where the lawyer is obtaining a fee. So, I mean, if the Rules Committee were inclined to make the rule more expansive, that's certainly their prerogative. But at this point, the goal is just to make the Connecticut rule in line with the ABA rule to provide for this humanitarian exception.
Thank you. That was very helpful.
Okay, Attorney Stovall, did I hear you right? There are 11 jurisdictions that have adopted some form of a rule such as this?
Yes, that's my understanding, Your Honor.
Has any jurisdiction not adopted it, rejected it?
Since the ABA adopted it in August, not to my knowledge. To my knowledge, this is the first time it's been considered by another jurisdiction after the ABA's adoption.
Got it. Okay. Thank you. Are there any other questions for Attorney Stovall? If not, how would the members of the committee like to proceed with this? I'm not certain it needs to be referred to anybody, but I'm maybe overlooking something. Well, why don't we do it as a motion to approve? Is there a motion to approve?
I thought Judge Pratt's had a question.
Oh, sorry, Judge Pratt's.
It's okay. Thank you. I just have a quick question because I was kind of thinking along the lines of what Judge Bellis was saying. And what is to stop a lawyer from taking on, for example, a criminal case pro bono, knowing that there might be a financial benefit to him or her if they take on a civil case like a 1983 civil action? I'm just knowing that he helped this person through a very difficult time when they're arrested criminally, but then they have the benefit of maybe a civil action where it just seems to me a fine line.
Well,
Has there been any issue with that where a lawyer will take on a case and represent someone pro bono, but with maybe an interest in the future that there may be some other where it might be benefiting the lawyer? You know what I mean?
Well, Your Honor, the rule does have within it that this kind of financial assistance is prohibited where the lawyer is using it as an inducement to the client,
Okay.
Holds out the promise of such assistance as an inducement to representation. So I
Okay.
think that would fit that. So the kind of thing that you're talking about
Okay.
would be precluded under the rule if that's why the lawyer offered the financial assistance.
All right, I got you. Thank you very much for that. Yes, thank you.
Thank you, and I apologize, Judge Pratt. I can't keep track of all of this. I apologize for overlooking you.
No problem. Thank you.
Is there any other? Okay. Is there a motion to approve?
Your Honor.
Attorney Del Campo.
Yes, Your Honor. Can I just ask Attorney Stovall one question? Because I'm concerned with which iteration you're voting on, because it's happened several times in these documents. And we found little changes in the language, and I just want to make sure that we're all on the same page before we produce this, if you pass it. I mean,
I apologize if there are inconsistencies between
there may not be.
Should I explain what the difference between the three attachments are?
Yeah, well, we just found one small nuance in the language. Attorney O'Donnell pointed out to me that, when it talks about E1, and E1, it talks about a lawyer may advance, but the language, I believe, in the practice book is a lawyer may pay, and you have that elsewhere. So I'm just not sure. That language is not changing in any event. I just want to make sure we're on the same page.
Your Honor, I mean, Mr. Del Campo, I think that probably the difference may be that there may be a difference between the ABA language and the CBA and the Connecticut language. So if there's a difference, that's my mistake in basing the new rule based on the ABA rule. But to the extent there are changes, there are no intended changes to other than what's indicated with underlining in the proposed amendment attached to the proposal.
Why don't we do this? This is the first time this is on our agenda. Why don't we just push this off to next month? I'd like you to get together with Attorney Del Campo and his team to make sure that we have one clean copy of what is being proposed, so all of the members have that in front of them for next month.
Okay, I'm more than happy to do that. And again, I apologize for any inconsistencies. So those are completely on my head.
That's fine. That's what this process is about. Is there any objection to proceeding in that manner? Okay. I don't have anything else on our agenda that I'm aware of. Attorney Del Campo, is there anything else?
No, sir. That's it.
Okay. Is there a motion to adjourn?
So moved, Judge Bellis.
Is moved, and is there a second?
Second, Judge Cobb.
Seconded. All in favor, say aye.
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 Opposed, say no. That passes unanimously. We stand adjourned. Stay safe, everyone.
Thank you.
Thank you.
Thank you, everyone.